Hey, welcome back to another bike law video. I'm Daniel Flanzig, a partner at the law firm of Flanzig & Flanzig, also known as New York Bike Lawyers. Today I want to talk to you about something that I think is very important and something you probably don't know that exists. And that is what happens when you enter into a user agreement with Citibike, Revel, Lime, or any one of these other companies. Because what you do, or what you are doing, is waiving away a lot of your rights. So there's something called a click wrap agreement. And that is when you click on your agreement to the terms of services. And if you ever spent any time looking into the terms of services, you would learn that Citibike and Revel are asking you to give up your rights to sue that company if there's a defect in their product or any other claims you may have, or waiving your right to trial by jury and going to forced arbitration. Nobody spends the time to look into these agreements, and they learn the hard way when there's a defect in one of these products and they attempt to sue the company. And next thing they know, they're being told, you can't sue us, you agreed to arbitration. And you're like, what are you talking about? And they send you over a copy of the 75-page user service agreement that says, I waived away my rights in order to sue you. So let's take a look at the Citibike agreement. Now let's take a look at the Revel agreement. And for those of you who are not familiar with Revel, Revel are electric motorcycles that originally were dumped in Queens and Brooklyn. And all you needed to do is show them proof of a driver's license and proof of age. And without any experience or knowledge in riding a motorcycle, and I call these things motorcycles, although you can call them scooters, you could then take out one of these devices and ride around Brooklyn and Queens. And now they've launched into Manhattan. And to much chagrin of a lot of cyclists, we're seeing them in the bike lanes and places they should not be. And I believe them to be a problem. But if you are involved in a crash with Revel, let's take a look at what the Revel agreement says and what you're giving up when you enter into that click wrap agreement. So the question now is, are these things enforceable? And I've been involved in a number of these cases. I've been speaking to my colleagues across the country with Revel, Lime, um, Uber, anybody that's running these programs, and we've all been discussing, are these things enforceable? And the majority of us are finding that they are enforceable agreements. And with Citibike on a number of cases has attempted to have cases outright dismissed in defects on the Citibike. And the defects can be in the fenders or any other portions of the bikes that were defective and the rider was injured. And I've seen a number of successful motions made by Citibike to dismiss those cases. But most recently, and this is about maybe 6 months ago, finally I saw a swing in a different direction. And that's a case called Gaydos, Gaydos versus New York City Bike Share. And again, Citibike based upon the 2017 agreement. And by the way, just to let you know how sneaky this was, your original user agreement with Citibike had no reference to this. And at some point, you got an email from Citibike saying, hey, we've updated our terms of service. And how many of you actually spent the time to read that terms of service? What was in that terms of service is what I just showed you, your waiver and your right to sue Citibike. So in Gaydos, they sue Citibike over a defect in the front fender. And Citibike makes a 3211 motion to dismiss, which is a pre-answer motion to dismiss, saying, hey, Mr. Gaydos, you signed this user agreement, you can't sue us. And the court said, not so fast. They said, number one, the general obligations law of 5-326, which is a great law, and that is a section of law that makes it against public policy for places of amusement, such as public parks, ball fields, things like that, when they're open to the general public, a waiver by the owner of that facility to limit your liability is against public policy. And the court said, we're not going to do this so quick. Your 3211 motion to dismiss, before we've had depositions, I'm not granting that. And also the court said, I'm not convinced that there is no claim with regard to your obligation to affirmatively maintain these bikes in good working condition. So I'm going to allow the plaintiff to have discovery and depose Citibike about how they are maintaining their bikes and whether or not they have an obligation to keep them safe to the user. So Gatus is a case we finally see moving in a different direction. So the good news is I think these claims with regard to Citibike are going to start to be viable or more viable, and these defenses of the click wrap agreement and you waiving your rights to sue Citibike seems to be something of the past for the moment. I don't know if they've appealed it or not. With regard to the other services, I think those are going to be more enforceable. So just be aware when you click those user service agreements, take a moment and read it and make sure you're okay with it. I mean, I don't know how much choice you are. Your choice is to walk away from using the product, but I think it's important for consumers to know this because most people don't realize what's happening, nor should they enter so blindly into these agreements without understanding the rights they are giving up. So that's a little bit about these click wrap agreements, the waivers and liabilities that are contained therein, and what you need to know to keep you safe. Be well. Talk to you soon.